morning. We're going on the record in this matter. This is case CR 22-21-1624, State versus Lori Noreen Vallow. This is the time scheduled for a hearing on motions that are pending filed by the defense. As we get started, a couple of procedural issues the court would like to take up. First of all, for the public in attendance, we do have an administrative order governing conduct both in the courthouse and within the courtroom. I would reiterate the prohibitions that are contained in the order governing courtroom conduct. On page 2 of that order, that cell phones, and I'll just read that to make sure everyone's clear on this, that's in attendance. With the exception of approved media and court personnel, all cell phones and other electronics must be turned off at all times in the courtroom. If a cell phone or other electronic device rings or beeps or is found to be used during court, it will be confiscated by the marshal. No one may talk on a cell phone in the courtroom, and also recording or transmitting any images or sounds from this courtroom, if you have not been previously authorized to do so as part of the media in orders the court's entered, is likewise prohibited. So I would request the public please comply with that order at all times during this hearing. I'll identify the parties at this time then. Mr. Wood and Ms. Blake are here on behalf of the state. The defendant, Ms. Vallow Daybell, is here represented by her attorneys Jim Archibald and John Thomas. In terms of these motions, to clarify for the court, who's intending to argue the motion on behalf of the defendant, counsel?
I am, Judge.
All right, Mr. Thomas will present argument on the motions, and who will be offering responsive argument from the state?
I will, Your Honor.
Mr. Wood will present argument for the state. The court would note that we did previously have scheduled a motion in regards to consumptive DNA testing that was set for today. The court has received a stipulation and an order which I've signed that resolved that issue, and so that is not being taken up for hearing this morning based on the order entered on that. What remains then for the court today are two motions as they relate to the charges that are contained in the indictment. Two separate motions, one as it relates to aggravating factors, and the other motion as it relates to counts 1 and 3 with the conspiracy charges. We'll hear argument on those motions. I will indicate one other procedural matter that upon completion of this hearing, the audience will be instructed by the security here in the bailiffs as to when you'll be leaving the courtroom for security purposes, so please remain seated until you're instructed to leave the courtroom upon the conclusion of this hearing. So going forward to the motions now, let me first just ask Mr. Thomas, is the defense ready to proceed with your motions?
Yes, Your Honor.
All right. And is the state ready to proceed this morning, Mr. Wood?
Yes, Your Honor.
Very well. First motion I'd like to take up then is the motion that was filed on July 12th, entitled Motion to Remand a Grand Jury for Probable Cause Determination as to Alleged Aggravating Factors. Why don't we start there, Mr. Thomas? I've reviewed your motion and briefing. I've reviewed the state's response as well, and if you'd like to present argument on that at this time, you may.
Certainly, Your Honor. Thank you. We would also, we have filed a motion to incorporate federal and state constitutional grounds in support of future motions and objections. That has not yet been heard. So I would just like to put that on the record that we are relying upon that motion, and we're relying upon the 4th, 5th, 6th, 8th, and 14th Amendments of the United States Constitution. There are about 70 cases that are cited in that motion. I can read those off for the clerk or for the reporter if the court is okay with that, or would the court like me to?
Well, we don't have that notice for hearing today, Mr. Thomas. I mean, I can take note that it's been filed and understand the request you're making there in terms of making any specific finding or determination.
Right.
It's not set for hearing. The motion's been lodged in the case, and I don't think it's necessary to put all the authority into the record on the oral motion at this time unless you think that's necessary. So it's up to you.
And I don't think it's necessary. I just want to make sure, for appeal purposes, that the court is aware that we are relying upon those constitutional amendments.
Okay, and I do understand that those are incorporated into your defense here, and we'll be considering those federal constitutional protections as well in this case.
Thank you, Your Honor. So the first motion that we're going to argue today is with regards to the aggravating factors. Your Honor, we believe that that there should be a probable cause hearing on these aggravating factors. Pursuant to our motion, we indicated that those aggravating factors enhance, if you will, the penalty, and therefore they are part of the punishment here. We understand the state's position, and we understand that the state's position, the Supreme Court of the state of Idaho's position, is that Abdullah is controlling law here. And we get that, but we are of the opinion that that there should be probable cause hearings on each of these aggravators for several reasons. One being that it narrows down the possibility of us having to prepare for a trial on an aggravating factor that doesn't fit, that doesn't meet the probable cause standard. There are other reasons that we've noted in our brief. We'd ask the court to consider those. As I said earlier, we understand that Abdullah is the law of the land here in Idaho, but as the court is well aware, especially this year, where the Supreme Court ruled to overturn Roe versus Wade. Roe versus Wade was the law of the land for a number of years, and then through time and change, they decided to overturn that. That was a landmark case, and we would just like to, for appeal purposes, put that on the record that we believe that it should be a probable cause standard as far as these aggravating factors go, and we would rely upon that for appeal purposes. We understand that the court is likely to deny our motion on that, but we would like that to be part of the record. And that's all we have on that.
All right, I have a question then, Mr. Thomas. If under your motion, who would make a probable cause determination? Are you suggesting, because this case came about as a result of a grand jury indictment, are you suggesting it would need to go back through another grand jury indictment or go through some sort of a hearing similar to a preliminary hearing where a magistrate potentially or me would determine probable cause?
You know, that would be a hybrid issue, and I don't think that would be appropriate. I think that it should go back to the grand jury to have them to decide whether or not this should move forward. I'm not sure that the Idaho statutes and Constitution allow for that hybrid, bring it back to a grand jury or bring it back to a preliminary hearing and let a magistrate or Your Honor to decide whether those are probable cause or not. I'm not sure that it would really matter, but I would think that bringing it back to a grand jury would be the more appropriate way to do it, since they were the ones who found the probable cause on the alleged crimes. I would ask that the court require that they also find probable cause upon the aggravating factors.
All right, thanks for the response to the question, Mr. Thomas. Mr. Wood, what is the state's response on the motion for further probable cause determination on aggravating factors?
Thank you, Your Honor. I'll be brief. As Mr. Thomas has pointed out, there is controlling law on this issue, directly on this issue in State v. Abdullah. It's a 2015 case, capital case, where the death penalty was found. And I'll just, this is in my brief, but I'll just read from it very quickly. This is a direct quote from that case. We also hold that there is no constitutional requirement that the state present evidence demonstrating probable cause for each aggravating circumstance to properly notify the defendant of its intent to seek the death penalty. And so, as Mr. Thomas did state, that is controlling. It's the Supreme Court of the state of Idaho. That analysis starts, their analysis starts with a discussion of Ring versus Arizona, which is the case that found that death penalty needs to be found by a jury. And that case has been interpreted by some to provide that there should be a probable cause finding aggravating factors, even though the Supreme Court did not actually find that. Abdullah goes through that analysis and comes to the conclusion that the Supreme Court comes to the conclusion I just read. where the Supreme Court has found that, where it's directly on point. I think this decision is already made for the court. I understand Mr. Thomas's argument that it's for appeal purposes, and we understand that. But as for this case, and under the current law, this is an issue that's already decided by the Supreme Court. There's no need for probable cause to be found of the aggravating factors. Idaho law determines how those aggravating factors are listed and how that notice of intent is given. And that has been upheld in Abdullah. And so for today, I think Mr. Thomas said it well. For purposes of appeal, they've raised the issue. But as of for this case today, I think this decision's already been made by the Supreme Court.
All right. Thank you for the response, Mr. Wood. Mr. Thomas, do you have any rebuttal argument to make?
No, Your Honor.
All right. The court's considered the motion then at this time. Given the nature of the case, in lieu of making a finding or ruling from the bench, the court will take this matter under advisement and will issue a written decision on the motion. That will be lodged once we've completed the research and written the decision on that. So that first motion will be taken under advisement. Mr. Thomas, then, if you'd like to present argument on the second motion, and that was your motion filed also July 12th, to remand the indictment to the grand jury for further proceedings, and in particular stating your objections to the listing of the offenses in counts 1 and 3 of the indictment. If you'd like to present your argument on that motion at this time, you may.
Thank you, Your Honor. Our main argument revolves around counts 1 and 3, that they're confusing to the jury. They would be confusing to a jury when they have to find this after the trial to find these elements. And I see that the state is saying that the crimes of murder and the crime of grand theft are not necessarily the crimes in the conspiracy. However, this doesn't make any sense because the conspiracy to commit murder and the conspiracy to commit grand theft are two separate conspiracies. And I'll go through that in just a bit. But we do believe that it would be confusing to a jury to be able to figure out what elements were met and when the elements were met and to what extent the elements were met. The burden is high. The burden is beyond a reasonable doubt. If they meet some of the burden at a different standard, perhaps a probable cause standard, or perhaps a more likely than not, or a different standard, that would be severely detrimental to our client. So I think one of the things that we need to think about in reviewing whether or not these charges, conspiracy to commit murder and grand theft in counts 1 and counts 3, should be split off or bifurcated. I think we need to say when does the conspiracy end? Well, one would think that the conspiracy to commit murder would end when the alleged murder occurs. That would be the end of the conspiracy. The state has pled in count 2 of the indictment that the murder of Tyler Ryan occurred on or between September 8th and September 9th. So that would be the end of that conspiracy. The conspiracy to commit the crime would have been completed, and the conspiracy to the murder would have been over. One would think that the conspiracy to commit grand theft ended when the grand theft was over. And the pleadings in count 7 of the indictment indicate that the grand theft would have occurred after the murder. The murder of Tyler Ryan was pled to have allegedly occurred no later than September 9th, and the murder of J.J. Vallow in count 3, that murder was alleged to have been committed on or before September 23rd. And so the grand theft was alleged to have occurred pursuant to their indictment between October 1st and January 22nd. So the conspiracy, while we can have a before portion of the conspiracy,
What was the October date?
October 1, 2019, and January 22nd, 2020.
Oh, thank you.
And so they're saying that the conspiracy while it could have possibly developed earlier, it could not possibly have ended in the same time that the conspiracy to commit murder would have ended. So the conspiracy to commit murder would have ended at the very least, at the very most, on September 23rd. The conspiracy to commit the grand thefts were committed between October 1st, allegedly, and January 22nd of the following year. And so those don't line up.
Well,
So-
Mr. Thomas, though, can't you have an ongoing conspiracy of different offenses? I mean, a classic conspiracy is like a drug conspiracy where somebody's doing a delivery of a controlled substance and then a week later another delivery and a week later another delivery, and that's all part of a grand conspiracy charge that would have multiple offenses. Isn't the time frame open through all of these charged offenses?
Sort of, but not after the conspiracy to commit murder. Once the murder is committed, there is no conspiracy to commit the murder. There's maybe a cover-up or a conspiracy to, I don't know, after the fact, some sort of other charge. But once the conspiracy to commit murder, once the murder is over, the conspiracy is over, right? I don't see how that could go anywhere further. And so with the conspiracy to commit murder over, I think that's where that charge ends. The conspiracy to commit murder ends at the end of the murder. And so I don't think that they can tag on a conspiracy to commit grand theft as part of the conspiracy to commit murder. And in fact, the state says that in their brief, they say that Idaho Code 18-1701 gives the punishment for conspiracy as punishable upon the conviction in the same manner and in the same extent as provided under the laws of the state of Idaho for the punishment of the crime or offense to which the combined had committed. And in layman's terms, I think, if I'm reading it correctly, and I may not be, but it says in layman's terms, this is what I feel, that if they find a conspiracy to commit murder, then the punishment is death. And that is the conspiracy to commit, that's the conspiracy. If the conspiracy to commit grand theft, the punishment would be up to 14 years in prison. And so it sounds like there are two possible punishments to this one conspiracy, either death or life in prison or 14 years in prison. And so to me, it sounds like there are two conspiracies. I understand the state's position where they say the conspiracy is the crime, not the murder and not the grand theft. But when you make a statement like that, you have to back it up with the facts that say, well, yeah, once they've committed the conspiracy, we have to now go to the punishment. And their punishment doesn't meet the crime. The conspiracy punishment is one of two or three different punishments, either death, life in prison, or 14 years. So it could be possible for this jury to find some elements of the grand theft, some elements of the murder, and say, maybe they met all the elements. We're not asking the court to, I did ask the court to strike the pleadings, but that was mostly in alternatives. Our main issue is we don't want to have to do this again. We don't want to have to come back before the court after the trial's over and it goes up on appeal and the appeal court says we couldn't make heads or tails of what was going on with this conspiracy charge. And so we think that it's just easier for the court to say, you know what, bring it back to the grand jury, have them split it off, have them do one conspiracy to commit murder, one conspiracy to commit grand theft. It's just that easy, and therefore it brings the jury into a position of we find them either guilty or not guilty, guilty of the grand theft but not of the murder, and it just makes it so that there's too many questions for the jury. I'm not saying that the jury isn't sophisticated enough to sort through that, but I've been practicing law for 20 years, and this particular charge baffled me, and I had to work through it, and I still am having issues working through it. And this is what I do for a living, so it just makes it all the more difficult. Another point, Your Honor, is that this is just fundamentally unfair. The state argues in line 5 of their jury instructions, says, further, the explicit language by establishing that the state needs to prove that the defendant intended that at least one of the crimes would be committed. They emphasize the words, at least one of the crimes. So in my mind, that infers that the defendant need not even contemplate the commission of the murder, only the grand theft, or vice versa, only the grand theft and not the murder. And so I have issue with the state saying, hey, we can lump all of these things into one conspiracy charge, and as long as they find one of those conspiracies, then the conspiracy is met. And so if we're doing that, then you're asking the jury to find not only was it murder, or was it grand theft, or was it something else that the state is going to come up with between now and the trial, and how do we punish that? And so now we have to go back to the jury and say, okay, so which conspiracy did you find? Well, we found that there was conspiracy to commit grand theft, but not conspiracy to commit murder. Or we found that there was conspiracy to commit murder, but not conspiracy to commit grand theft. And so now we're looking at, it just jumbles it up, and it doesn't make a lot of sense to do it that way. And we're bringing it before the court because we believe that we're just looking for a fair trial. We just want the jury to be able to go back to the jury room and say, yes, this is the conspiracy is to commit murder, or yes, this is the conspiracy is to commit grand theft. That's all we want. That's all we're looking for, is a yes or no answer that the jury would need to come back with. Further analysis would just be, I don't know that it's appropriate, and I don't think it's fair for the jury to have to do that. The state further takes issue with my 8A argument. They indicate that 2 or more offenses may be charged. I say that the 2 or more offenses may be charged on the same indictment. However, Criminal Rule 8A indicates that those charges need to be separate counts. And so the state's attorney says that there's one conspiracy for two different crimes, and I'm not analyzing that, and there's no analysis to that. Well, my analysis is, Judge, the state's wrong. The state needs to realize that, yeah, this needs to go back to the grand jury, and it needs to be conspiracy to commit murder, conspiracy to commit grand theft. The state goes on to make an untimely argument, that we are untimely in our arguments. We would ask the court to rule on the merits of the case and not on the untimeliness. The state has, in my opinion, the state has waived their right to make this untimely argument. We got their response to this motion just 6 days ago, which is, in my opinion, untimely. I think a 7-day notice is pretty standard around the state. Also, the state, the court is aware of how much discovery is involved in this, sorting through that, and perhaps, I wouldn't even say that normal cases we would be able to find this within the 28-day time frame that the legislature has or that the rules have established. But this particular case, is far in excess of the time frames and the process and the time needed to just digest this case and the discovery. And the state, when I filed my discovery my discovery request on April the 18th, the state failed to respond in a timely manner. They responded timely, I guess, I should say that, on May the 2nd, which would have been the 14 days. But they responded by telling me, oh, by the way, we'll get you your discovery within 14 days of May 2nd. So they were untimely on that, and yet they're telling me that I need to, I was untimely on filing this motion, and that I should have come to the court for relief and request. I would also note that the docket indicates that the court didn't release the testimony of the grand jury until June 21st, 2022, which is far beyond the time frame for us to file a 12B motion, which I think is excusable error based on the fact that we didn't have the information that we needed to dig into the indictment and dig into the things that we needed to do. Your Honor, in closing, I would just say to the court, and I know that the court is well aware of this, that a person's life is on the line. The prosecutor for the state of Idaho represents the interests of everybody in the state, and that includes the defendant. They are duty-bound to look out for the procedural interests of the defendant, and what they're arguing, in my opinion, Your Honor, is wrong. The state's attorneys here are here to seek justice, not just a win. And they're here to protect the Constitution and the rights of all those in the state of Idaho, including those that they're prosecuting. And so I believe that the appropriate way to deal with this indictment is to return it to the grand jury and just have them split the two conspiracy charges so that it's easier for a regular jury, for a trial jury, to understand and to sort through this. Thank you.
All right. Thank you, Mr. Thomas. I'll hear a response from the state. Mr. Wood, I'd like to start off with the issue raised there at the end that was raised in your responses to both of these motions, that they were failed to be filed timely under Criminal Rule 12B. And let's start there and then move forward with the substance of this motion. So if you'd like to present any argument at this time, or notify the court if you're still holding on to your objection on the timeliness issue.
Thank you. Your Honor, we do maintain that objection. That's why we put it in our briefing. We do understand that 12B is a